And now, it's The Law Show on CL 650, a comprehensive look at everything you need to know about the law.
And I'm Zach Spencer. Welcome to the show here on CL 650. Today we're talking about estate law, estate planning, and joining us in studio are John Lakes and John White, partners at LakesWhyteLLP in North Vancouver. They're experienced in estate planning, estate litigation, and today we're going to be talking about the basic rules of what constitutes a will, and even more important, you must be properly prepared because the court might intervene if something goes sideways here with your will. And John, I think we'll just start with the one line here we have about the problem with if something goes wrong with a will. What do you basically say to people about what your will means?
Well, your will is your last will and testament, and the term is used because it's you're speaking to the world after you're gone as to this is what my last message to the world, and this is how my assets are to go, and who's to be in charge. And the problem is if you don't have it done properly, then of course you're deceased. And at this point, we do not accept Ouija boards or anything as evidence in the courts. So you're relying on whoever's trying to figure out what you mean to say. They're relying on the will or whatever will document there is, and maybe other evidence such as people's comments or documents. And of course you don't want to go there because first of all it's very expensive to go to the court, and if the court has to intervene, the costs come out of your estate, and you've worked hard to earn what you have, and last thing you want to do is spend another $30,000, $40,000, $50,000 in legal fees just because you didn't bother getting a proper will done at $500 or $1,000. So
yeah. And that's basically the price range of doing it right.
Yeah. So it's important because you're not there and everybody needs certainty.
And that's what we're going to talk about today. So we just wanted to set it up that you can't give the message once you're gone. You have to do it before you go and set it up properly. And John, that's where you come in, is if you have to go to court, you go in front of the judge and you have to try and figure out, basically, is it like solving a mystery? What did the person really intend?
Well, it can be. I mean, the court is interested in one of these unfortunate situations to try and determine what the will maker intended. And depending on the sort of application that I'm bringing, there are various types of evidence that we can bring. I mean, there are some cases where you can't bring in direct evidence of what the will maker said or perhaps wrote down outside of the will, except in some unusual circumstances, such as the will's ambiguous on its face, or it's meaningless, or things like that. And there are now statutory requirements for conditions like that to be met before you can even tell the court, yeah, he left a letter outside of his will that answers the question what he was intending.
But will it be allowed to be seen, right?
It depends, as I say, it depends on whether, as counsel, I can present enough admissible evidence to show that the will is ambiguous or the provision is meaningless. And it's not as easy as simply presenting a letter that one may have found in the deceased's desk drawer.
Right. So that's why when we go through all of the items we're going to talk about today, that's why I wanted to set it up that, first of all, this is your last message to the world, and then if you get it wrong, then you have to possibly go to court, and maybe something that you thought would be allowed is not allowed to be heard, to decide where your will is going to be, I guess, divided with your family members or what have you. Before we get into that, you're both from North Vancouver. Your practice is in North Vancouver, and but you must have people from all over.
We do. We have people from all over the Lower Mainland, and indeed, we've had clients all over the world. But the majority of our clients come from North and West Vancouver, and increasingly the Sunshine Coast, which is sort of
up to Squamish now. People are commuting from Squamish, I hear. Yeah.
Some of the people in our office commute from Squamish.
Mm-hmm. And you have free parking, I understand.
Absolutely.
Well, that's a deal.
Lots of it, too.
Lots of it. Good. All right. So today we're going to get into the rules, how it must be prepared properly, executors and trustees, and a whole bunch more. So, John, why don't we get into this? You talked about this is your farewell message to the world. The executor has got to be a very important person when you're gone, they're the person that's going to stick handle how your will is going to be divided, right?
Well, every will needs an executor. The executor is the person appointed to look after your affairs. So after you've died, there's a period of time where nobody's really technically in charge until letters probate have been issued. But the job of the executor is, first of all, to determine what your assets are, try to find out the situation with CRA, determine who your beneficiaries are, and once they know a lot of that information, they will then make a submission to court to be appointed in charge of the affairs. That's being appointed the executor. And then once they're executor, their appointment is retroactive to the date of death. But if this was a baseball game, when you become executor, you get to first base. Mm-hmm. So you've still got quite a few things to do, but you at least have some status. And it's getting more and more important with privacy acts. The banks can tell the information. If you've died and you're in the process of litigation, the lawyer can now tell the executor what's been going on.
So you have to be recognized as the executor.
You have to be recognized as a legal representative and the legal successor for that person, so they can then start assembling the assets. So every will needs an executor. It's important that the people you appoint are willing to do so. You should have somebody a resident of Canada. So if you've got 2 daughters who live in California, it may not be a good idea, because there may be a taxation issue. But there's 2 ways to resolve it. Either, if you're only in your 50s and your daughters are in California now, you say, well, I'm going to appoint them as executors now, but if when I die, the tax rules are totally terrible, they can resign. So and then you, and if you're, you don't appoint your 89-year-old aunt to be your executor either. So
is it always a good idea to name somebody who's younger than yourself?
Well, not necessarily. It depends on your age too. It depends. I mean, you can also name a backup too. So, for example, you may want to name your brother who's 10 years older than you, and you could name him as your executor. But then you've got the nephew who's only 21 right now, but maybe you're hoping by the time he's 30 he could be a backup too. So you can name a backup as well too. But there's real important issues, because if you appoint a reluctant executor, then they may not be willing to act, which creates another problem, which John's going to talk about right now.
Well, I mean, the worst thing, the worst, or worse still than appointing a reluctant executor is appointing an executor and not telling them.
Right.
We've actually.
I think that happens all the time.
Well, it happens. I know it happens. I mean, we've just seen a case like that where the mother of what I think could fairly be called a dysfunctional family appointed a friend to be her executor. The friend had no idea. And the friend looked at the family dynamic and realized what a mess it was, and decided that she didn't want to get involved in this. And you can't blame her for that. Being an executor is a tough job, and you really want to be careful when you select an executor that the person you're selecting is up to the task, both in terms of maturity, hopefully in life experience, and in temperament. And if you've chosen someone who is simply not up to the task, you may find, well, you won't find because you're dead, but your beneficiaries may find that person resigns, and then quite often it's left up to the courts on application to determine who is going to step in and administer the estate. And
that's when you kind of lost control, right? Somebody else is instead of somebody you know.
Well, it certainly can be that way. There are provisions under our new estate legislation, the Wills, Estates and Succession Act, for sort of a system of priorities. Who is the priority applicant in this scenario? It's essentially somebody who has the support of the majority of the beneficiaries. But even that doesn't necessarily mean that they're going to get appointed. The court may look at, again, things like family dynamics. If the majority approved beneficiary is in a personal conflict with another potential beneficiary, it's quite possible for the court to say, you know what, we'd be creating a problem here if we appointed you. Go find somebody else. And that somebody else might be For example, a trust company. I mean, there are trust companies who act as executors, and they have tons of experience. Our view is that they can be somewhat impersonal and bureaucratic, which is the downside, I guess, of being professional executors. But they're also expensive, and appointing a trust company in that circumstance is departing a long way from what the executor wanted.
Well, that leads me into the next point is that...
I just want to raise one other issue with the executor, too, though. When you do a will, you don't have to tell anyone the contents of your will. You can just ask them if they're willing to do it.
Right.
And, generally people look at their own family, but, now with dynamics, a lot of people don't have family around. So you want to make sure if you're going to ask your friend Mary to be the executor, and she said, well, I'm moving to Hawaii next year, you've got to sometimes find out what their plans are, too.
Is it better to have somebody in the family that's maybe too close to the fire versus somebody who's outside of the family? In your experience, what do you think?
Well, generally family members are the best members because, most estates get resolved. Most families can get along. Most families know what the executor wants. And I can tell you it's, the problem is if you end up being an executor for a stranger, which I've had to do a few times, you have to go through the sock drawer. You have to go through the underdrawer drawer. You end up doing things, learning things about a stranger you may not want to know. Well, if you're a family member, you know that mom's a hoarder or whatever.
Yeah.
So I would say, depending on the dynamics of the family, and sometimes what happens if, let's say, you've got two sets of kids, you may want, let's say, the man who had two children from first marriage and two kids from second marriage, maybe what you can do is you name two executors, one from each group.
Right.
So
Yeah.
it's a lot of work, but it's also a responsibility and honor.
I just want to comment on that last point because that might be a situation where you might be tempted to appoint two executors. For me, I really believe that you ought to have one executor. You ought to have one person running the show. I like to tell people that being an executor, it's an honor, but being an executor is not a democracy. It's a benign dictatorship. You have to have somebody who has final authority when disputes arise. I came across a case recently where a will maker was proposing to appoint two executors so that they could essentially serve as checks and balances, one against the other. And there's so much wrong with that.
Sounds like the U.S. government.
Yeah, exactly. A will is not, as I say, it's not a democracy. It's not the U.S. government. And the checks and balances for the executor are provided by the duties of the executor and the liabilities that the executor faces if he or she doesn't perform those duties. There is plenty of room for court supervision to provide checks and balances. But when you have more than one executor, at least in my experience, you are setting up the potential for conflict between executors, which can be very hurtful for families after you're gone. I've seen families, brothers and sisters, who don't speak to each other now because they fell out as executors.
But this is why lawyers always disagree with each other because, see, the problem is John only sees the bad ones. Okay?
Yes, he goes to court.
Yeah, so maybe out of 10 estates that we deal with, he'll see one. So, for example, if you have two kids and they both like each other, well, you're going to appoint both of them because one person's feelings may be hurt or something like that. So you've got to look at the dynamics of the family to determine
you know your own family better than anybody.
Yeah. So.
Well, we are just getting started here on what you need to do, the basic rules, what constitutes a will, and how everything should be properly prepared. It's very important. We're speaking with John Lakes and John White from LakesWhyteLLP in North Vancouver, and we'll pick it up next about trustees here on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.